and quash the orders of the High Court. The interested parties say that because Mr. Godwin Edridge Temeklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself.
After the 2024 general election, in NPP, and then somebody who asked, and some see, no, a bini then. You know, with some of the parliamentary seats, problem eba home, and then according to the EC, no, or say their officials they were under duress. In other words, now say force be and as a pressure be, NDC for no more pressure, and more declaration be an inquest somewhere. So the EC edging home says Sebi, also quite recalling na yenya correct results na ankasa. And then after said the EC made this announcement, the NDC omuko court Edward Monsem Koda High Court said Sebi asem na EC ne kano nyansa ni mma wo. So the High Court also stopping EC from recollating. And then they made this application on the 16th of December. And then the next day, which is on the 17th of December, the NPP also filed for mandamus law. In other words, I'm also making mandamus application. And then somebody asked a mandamus here. You know, with the mandamus, everyone says, "Oh, say, obedient to me be mawa," and now file for the application. So it is in the 1992 Constitution for everyone to also benefit from it. Now, when this case went to the High Court, Roman father said, "One open in Tamako Brunya." So we need time we say we beti NDC for one seminal. Any wabo assembly nagu. By case we beti a mandamus, you know, which is giving the EC the audacity to go on with the recollating. When this issue came up, Sebi NDC for an assembly and your model. So more the assembly na Supreme Court. And then when the Supreme Court or Tana Assembly in national who said the High Court judge in the Roman father. What's the Roman father? How do you make him? Bronya ba kwa yeku di asa odi mlikado do. So according to the Supreme Court, there is niye yeni na no wabwagu. And then somebody asked wabwagu sesen. Now according to the Supreme Court, which rema 4 seats be announced say one NDC for no. Sebi wabo that recollating results na isi niye yen wasen abwagu. And then somebody asked what are some of the 4 seats? Now the 4 seats include the Tema Central, Ablekumanov, the Okakwe Central, the Techiman South. Wabo sign results in Nagu, which is the recollating results na isi de bayeno. Waboni ni Nagu. But according to the Supreme Court, they should take the whole case to the High Court again. And then, because of say Roman father Abrenti, I was here the case, you know, Emma will be on the own pen in Tamako de Brunia for them to sit on this whole case. Jenyan to Wasenian Koti Asema Supreme Court edituja nearby Asema Ora Bagbins, Sanso de Ababo and Tena Nodi.
The interested parties say that because Mr. Godwin Edridge Temeklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of the Sawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabikwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set out. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Hafuanon North are not affected by this order, by this our order, and in effect, those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed, yeah. Now, those which have been quashed, sorry. Those which have been quashed, yes. To file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court, ex parte, Ajua Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Release B and C are hereby dismissed.
Okay, so that's the Supreme Court. Indeed. You know, ora Bagbins so the same year to Jan and somebody to Jan and say, the easy ni ye ana recollate no or so one on any time no ba stress I'm crofo na eche easy ko yi wo muni na ono one gin to mun engine to mutina so say easy ntia say onko no onko shefo Ghana ma hanum eye bije show me so kai so be subscribe afin so we share link no ma for and the next thing is to leave a comment.